TV 484 Colborn versus Netflix et al. Appearances, please, starting with plaintiff.
Attorney April Barker appears on behalf of the plaintiff, Andrew Colborn, and co-counsel Michael Griesbach is also present online on the phone. Good morning.
For defendant Netflix.
This is Lita Walker of Ballard Spar appearing on behalf of Netflix along with James Friedman. I may have colleagues on the line, but they won't be speaking today.
Okay. For defendant Crow Media, Laura Riccardi and Moira Demos.
Yes, Kevin Vick appearing on those defendants. I'll just be observing today. Thank you.
Okay. And for Michael Griesbach.
Attorney John Mayer, M-A-Y-E-R.
So good morning, everyone. We're here for our motions hearing in this civil case. By way of background, the plaintiff, Mr. Colborn, filed a defamation complaint against these defendants on December 17th of 2018 in Manitowoc County Circuit Court. The complaint alleges defamation claims related to the Netflix series Making a Murderer. The case was removed to federal court on April 3rd of 2019. There were some initial motions to dismiss. Then the plaintiff filed a second amended complaint on January 3rd of 2020. There were more motions to dismiss proceedings, I should say. Those were pending, and on September 21st of 2020, the case got reassigned to me after I took the bench. On May 26th of 2021, the court entered an order denying the motion to dismiss. We, about 2 months later, last July, entered a scheduling order setting an April 8th, 2022 discovery cutoff. That has since been amended, and there's some, at least to allow depositions after that date. There were also expert disclosure deadline was set for the end of April 2022. Expert discovery cutoff throughout initially July of 2022, and that's got pushed back, I think, to November of 2022 at this point. Dispositive motions initially would have been due a couple weeks ago, and now they are due, I think, in September. So that scheduling order was put in place. There have been some amendments to it, and then we had some initial discovery battles that were withdrawn, and then on March of this year, defendant Netflix filed a motion to compel. That's at docket number 206. That was filed on March 22nd. In the motion, Netflix seeks to compel respondent Michael Griesbach to produce documents related to 11 requests that were in the subpoena. The respondent is the co-counsel for the plaintiff. As I understand things, he's also the former assistant district attorney in Manitowoc County. He was involved, at least in some degree, in the events that are depicted in the series and that are the subject of the complaint. He may have actually appeared in the initial series, I think. He's also the author of 2 or 3 books on the events and on the series. The motion indicates that the respondent has flatly refused to respond to any of the document requests, asserting multiple objections. A couple weeks after that motion was filed, the plaintiff filed a motion in limine seeking to bar admission of the opinions and statements of Michael Griesbach at trial, arguing that they are inadmissible lay opinions, they are irrelevant, they are hearsay. About a week later, the respondent to the subpoena, Michael Griesbach, filed an opposition to the motion to compel, arguing that his opinions would be irrelevant to the defamation claim that's at issue, noting that the subpoena creates a potential conflict of interest in his representation of the plaintiff, argues that the documents are all otherwise publicly available, and also raising the reporter privilege under with that section 88514. The next day, Netflix filed a expedited motion under Local Rule 7H to hold briefing on the motion in limine in advance, arguing that we don't have a trial date yet. The motion in limine is premature. A week later, plaintiff filed an opposition to the motion to stay briefing on the motion in limine, arguing that there's no per se rule against filing an early motion in limine. Then on April 26th, Netflix filed its reply in support of its motion to compel. It argues that the documents it seeks in the subpoena are relevant and are certainly subject to the broad parameters of discovery, even if potentially the documents aren't admissible themselves, they could lead to the discovery of admissible evidence, which is the standard. Netflix also argues that the documents go to the defamation claim, whether the claims are the documentary itself and the statements made in it are defamatory, and they also go to plaintiff's reputation and whether there are any damages. Netflix also filed a motion to restrict documents that were filed in connection with its reply brief. As I understand it, these are documents that were produced by plaintiffs in discovery. Otherwise, the plaintiff has broadly designated the entire email production as confidential, although the documents aren't separately stamped confidential. And so Netflix wanted to bring those to the court's attention, but given the obligations under the confidentiality order, it was required to designate them confidential. It does not believe they warrant confidential treatment, but it is abiding by its obligations under the protective order to designate them and then to at least raise the issue. On May 10th, Michael Griesbach filed a reply brief in opposition to the motion to compel. To call the reply brief, actually a response to Netflix's reply. So in essence, it's a reply. On May 16th, Netflix filed a motion to strike the second opposition brief or the reply, noting that it's improper under Local Rule 7I and noting that there was no motion for permission to file it. On May 17th, the plaintiff filed a response to the motion to restrict documents that were filed with Netflix's reply. Plaintiff argues that there is an unidentified third-party, or not unidentified, a third-party production company that has some sort of interest in the emails that were produced, that they were going to notify that third party, and the document should remain under seal until the third party has a chance to intervene and object. Also that same day, Netflix filed a reply on the motion to restrict, explaining why they filed the documents under seal as required under General Local Rule 79, and also suggesting that maybe we give the third party a deadline to respond and intervene if we're going to consider these things confidential and restrict them from public viewing. And so with that very long introduction I think we have 5 pending discovery motions. My inclination, I put this on for hearing because I figured it was easier to walk through them and give you the court's views and to resolve them so we can move this case forward rather than try to write something up. But before we weigh into the substance of these 5 pending motions, are there any updates from the parties, anything they would like to bring to the court's attention other than what's already on the table? Let's see. Ms. Walker, I'll start with you because Netflix has got the first motion.
Nothing to add to the procedural history here, Your Honor. I would only add that Mr. Colborn has brought not only a defamation claim, but a claim for intentional infliction of emotional distress. And I think it's clear from our briefs why that additional claim matters here when we're talking about the relevance of what Mr. Griesbach may have in his possession. happy to talk more about that. But I just wanted to clarify for the record that there's two claims, one for defamation, one for intentional infliction of emotional distress.
Thank you. And I did not mean to, obviously I was giving a summary, not a
Understood.
an exhaustive listing of every issue. But that's a good point. Thank you for that. I guess I'll go next to Ms. Barker. Anything from the plaintiff that you'd like to bring to the court's attention before we proceed to the motions themselves?
The only thing I would add, Your Honor, is that I have, following the reviewing the reply filed by Netflix on the motion to restrict, I have supplied counsel for Ms. Schuler, who's the witness or discussed in their reply, with copy of the motion documents and our response and Netflix's reply. And I have done the same as of yesterday with respect to whom I understand to be the principal of Transition Studios, who's technically the corporate entity that I believe claims an interest in at least some of the documents involving Ms. Schuler's communications. I have not yet heard a response from them, and I don't know that Transition Studios has retained any counsel. I will also, if I don't receive confirmation from Transition Studios that they received my email message, then I will also mail it. But at least efforts have been made to provide those parties with copies of the pertinent motions.
Thank you. Thank you. Mr. Meyer, anything from you before we proceed to the substance?
I don't think so, Your Honor. Thank you.
Thank you. And Mr. Vick, you indicated you were sort of just monitoring. Did you have anything to report before we get into the substance?
No, I don't. Thank you, Your Honor.
All right. So I'm actually going to take the motion sort of in reverse order. So let's start with Netflix motion to strike the second opposition / surreply. It seems to me that it's labeled an opposition, but it is a surreply brief. And under the local rules, you don't get a surreply, at least not unless you ask for one. And there's a procedure for asking under local rule 7I, and you have to file the proposed brief as an attachment and ask court permission. No permission was granted here. No attempt to get court permission was granted. So I'm inclined to grant the motion to strike. Am I missing anything? Ms. Walker?
No, that's absolutely right.
Mr. Meyer?
No, Your Honor, I don't think so. And our expectation was, as exemplified by our lack of response, that brief would be stricken. The truth is, it's entirely legal argument, which can be presented anyway, and so it isn't. Which is why we didn't proceed to seek leave after we were told we shouldn't be filing this brief. But thank you, Your Honor.
All right, so that motion's granted. Next, docket number 219 is Netflix motion to restrict the document. Sounds like maybe we sort of halfway resolved this one already. I think under the local rule and under the protective order, the fact that the document has been designated confidential makes it appropriate, at least initially, to keep it under seal. And I appreciate Netflix's compliance with those procedures, even though Netflix doesn't believe the documents should in fact be are properly designated confidential. Sounds like, as I understand it, that the plaintiff doesn't necessarily feel strongly that these materials are confidential and should be maintained under seal. The concern is primarily whether Ms. Schuler and this Transition Studios, these third parties, may have an interest. Let me just confirm that. Ms. Barker, is that correct? Do the plaintiffs contend that these materials should be considered confidential and maintained under seal, or is it mainly just trying to protect the interests of these third parties?
Yes, Your Honor, the latter is correct, or at least to do, at least give them an opportunity to talk for themselves. And frankly, the most concerning of them as far as allowing the third party to speak is a copy of an agreement. I guess I won't say anything else without divulging confidentiality, but just or a form that I think is designated as Exhibit 1, and that's, if it weren't for that, I'm not even sure I would be as concerned. But I think that in light of that, we wanted to at least give them an opportunity to chime in. Plaintiff personally does not have, or plaintiff individually, I should say, does not have a reason to designate them confidential in our view.
Okay. So what the court's going to do is I will grant the motion to restrict in part. In essence, I will keep those documents under seal for another 14 days through June 8th. If the court does not receive any objection or support from these third parties, any submission from these third parties explaining why these materials should remain under seal, they will be unsealed on June 9th, but I will give the third parties until June 8th to make a filing to justify, if they choose, keeping the documents under seal. I will also, and I'd ask Ms. Barker we'll do a minute order at the end of this, and I'd ask that you send a copy of that minute order to those third parties to notify them that they've got this time to file something. I'll also just note that I'm not at all sure that there's anything, even if they did object, that there's anything in these documents that would warrant sealing them from the public. There is a presumption in the law that documents that are filed in a federal court are open to the public. The First Amendment right of access to the courts that the public has, the media has, essentially to gain access to documents, especially adjudicatory facts. They're called documents that are relied upon by the court in deciding motions. Those things become public unless there is in very limited circumstances, they can be maintained in confidentiality, but it's really hard for me to envision how that would apply here. So that's my initial inclination, but I don't want to rule without giving the third parties at least an opportunity to address the issue, and they will have until June 8th to file something.
Judge, before you move on, I wanted to add one thing, but just before you move on to the next motion.
Go ahead.
So I just wanted to orient you a bit to who these third parties are and how many documents are at issue, and I think will be filed with the court in the future, such that we may have to go down this road again. And I think we mentioned in our reply brief that you may want to instruct the third parties to address things a bit more globally than the discrete documents filed with the reply. So very briefly, Brenda Schuler was deposed Friday. She's a producer for Transition Studios, which is making a counter documentary called Convicting a Murderer. We've received from the plaintiff approximately 4,000 text messages between him and Ms. Schuler that are relevant to this lawsuit. There were 80 exhibits at her deposition on Friday, and these are, frankly, some of the most interesting and relevant documents in the case from Netflix's position. So I suspect that to the extent there's more motion practice, and certainly at summary judgment, a lot of these documents in which Ms. Schuler and the studio purport to have an interest are going to be filed with the court again, and you will do it under seal again, and they'll have 14 days again unless you want to address it at the outset or ask them to address it sooner rather than later.
So thank you for that. I appreciate that additional context. Right now, this is the motion that I have in front of me, and I will give them an opportunity to object. I mean, I don't know what positions they're taking at this point. To the extent they file an objection in the next 2 weeks, it's possible that the court would set another hearing, and then we would address it and perhaps have a more fulsome discussion as you're suggesting. But if they don't file anything, we'll just resolve this one, and then we'll deal with it next time. But I appreciate that. I appreciate that heads up. Again, I'm skeptical that any of this stuff warrants sealing and being hidden from the public. But we'll deal with that if they file something.
Your Honor, this is April Barker, could I briefly just note something as well in response to Ms. Walker's comments?
Sure.
Yes, I just want to note that from the plaintiff's perspective, the text messages Ms. Walker is describing involve, in many cases, what appears to be work on this Convicting a Murderer documentary, which has not been released yet. And from our perspective, we are at the same time, Netflix is telling us none of these should be designated on behalf of Transition Studios as confidential. It has designated all of the email messages concerning a 7-year-old documentary making a murder that is at the heart of this case confidential. So certainly if, 7-year-old email messages between Netflix people regarding a released documentary can be designated as confidential, we should certainly, in our view, at least offer Transition the opportunity to explain why it claims that some or all of the messages pertaining to an as yet unreleased documentary should remain confidential if that's the position that it takes. And I would also appreciate it if we could attempt to work these things out prior to bringing them to the court's attention. In this case, as we noted, we think that the protective order designations are subjects that should be raised between counsel through a meet and confer pursuant to the provision in the protective order that says so. And that's not only good practice, but just common sense as well.
You will never hear me dissuade you from meeting and conferring.
Thank you, Your Honor.
So in terms of, I don't have any motion in front of me on any documents that Netflix may have, or the other defendants may have designated as confidential. Obviously, if there's a dispute about that, try to meet and confer, try to work it out. If you can't work it out, you can file a motion and we'll deal with it. I would, I guess, and I've sort of given a sort of high-level prediction of what my ruling would be with respect to these third-party text messages. I'm not exactly sure why any internal Netflix emails or text messages would be different. But again, I don't have any of the context, and I don't have anything before me, so I'm not gonna rule. But I suspect that the if to the extent they are similar documents and the issue is the same, you could probably expect a similar ruling. But again, there's nothing before me. I'm not going to rule on that now.
Understood.
Anyway. Thank you,
Your Honor.
Sure. And so that's that. Like I said, we'll put that in a minute order. Let's next take up the motion in limine and the motion to hold briefing on the motion in limine in abeyance. My inclination with respect to the motion in limine is to deny it without prejudice on grounds that we are so far away from trial that for the court to rule on, we haven't resolved summary judgment yet, so I don't even know what claims are going to be left, what issues are going to be left for trial. So it's, I think, premature at this point to decide what goes in front of the jury and what does not. So my inclination is to deny it without prejudice as premature, and then the motion to hold the briefing in abeyance, I would just deny as moot. That's my inclination, but I will let the parties try to explain whether they agree with that or why that is wrong. Ms. Barker, it's your motion.
Thank you, Your Honor. And I understand that a decision to take up an early motion in limine is a discretionary one. The reason that we had respectfully requested that the court considered in this context is because this is obviously an incredibly unusual situation and circumstance in which one of the attorneys for a plaintiff is being postured as a potential witness, at least in Netflix's brief. And, with respect to trial preparation, it certainly would be helpful to the plaintiff to know whether one of the attorneys on the team is going to be called as a witness at the trial, and if so, to what extent. Further, the issues that we were seeking guidance on are issues that probably will be, I'm assuming, considered with respect to the motion to compel as well. So it was an effort as well to allow for judicial economy. However, again, if the court prefers to take this up at a later date, then that's obviously what we will have to make adjustments accordingly.
Yeah, I think, thank you. And I do think it's just too early to rule on a motion in limine. And the reality is, and we'll turn to the motion to compel next, but I think the reality is that Mr. Griesbach has, some history with this documentary and these issues before this case was filed. And that just kind of is what it is. And that creates some unique issues in this case and puts him maybe in a unique position with respect to a trial and representing the plaintiff. And how that all shakes out is not exactly clear to me at this point. I don't know enough to make final rulings on all that, but those facts are what they are, and those are issues that are just will be lurking for a while, and that's something that I think the plaintiff and plaintiff's counsel are going to have to wrestle with and make their own decisions as we move forward. But I'm not inclined to make sort of final rulings on evidentiary matters at this point. I think it's premature. So the motion in limine will be denied without prejudice as premature, and the motion to hold the briefing in abeyance will be just denied as moot. So then let's go to the we've sort of dealt with a lot of the subsidiary things. Let's turn to the main, motion before the court presently, which is Netflix motion to compel. I tried to summarize this a little bit as I was going through the procedural background, but my understanding is that they've served a third-party subpoena on Michael Griesbach, who also happens to be one of plaintiff's counsel. Again, my understanding is that he was at one time an assistant district attorney in Manitowoc County who had maybe was not a main character in the underlying events that are described in the documentary, but was involved at least on the periphery, then thereafter wrote a number of books related to both the events described in the documentary and on the maybe one or both of the documentary series. And so Netflix is trying to obtain any documents that he might have that are responsive to these document requests. I have not gone through the specific document requests in detail, mostly because it didn't seem like the party's fight was about the specifics of those requests. The fight is more, let's say, on a more broad basis to whether he needs to respond at all. And my understanding is the respondent has flatly refused to respond just in its entirety. So that's my understanding of the background. And my understanding the objections are basically that the materials he has are not relevant, that there's this potential, it's awkward because he's counsel for the plaintiff, so there's a potential conflict of interest. There's an argument that the documents are otherwise publicly available. To the extent I understand that argument, I think what the respondent is arguing is that because the documents are publicly available, it's unduly burdensome to require him to produce them when the plaintiff could just go get them from the public record. And I also understand that he's raised this reporter privilege under WSDAT section 88514. So with that sort of as the backdrop, rather than having me just summarize your arguments, I will give now the parties a chance to sort of flesh out in greater detail what their arguments are and what it is you'd like the court to do today. Let's start with Netflix because it's your motion.
Thank you, Your Honor. And I think you've given a briefer summary than an attorney like me would, but your summary was accurate. And so thank you for letting me elaborate just a bit on what we believe are the key questions. And so, I think you've hit the nail on the head in saying that it's really the awkwardness that Mr. Griesbach is feeling as a result of sort of the multiple hats he is wearing that brings us to court today. I think if he were not counsel of record, he would not have flatly refused to produce documents, and there probably would not be a motion to compel, because for all the reasons you've stated, going back to Stephen Avery's exoneration in 2003 up through really post-release of Making a Murderer, when Mr. Griesbach reached out to the filmmakers and congratulated them and then wrote his own book, it's unquestionable that he has personal knowledge and documentary evidence regarding a significant number of questions central to this defamation lawsuit. And as you've, I think, alluded to and seem to sort of intuit, the case law doesn't immunize him from discovery just because he's counsel of record. And so, what I think this really boils down to, what his argument is at the very most basic level, is that a lot of the responsive documents he has relate to the underlying events that Making a Murderer documents. In other words, he has a lot of court files, deposition transcripts related to the murder trial of Stephen Avery and Brendan Dassey for Teresa Hallback. And his position seems to be that those are publicly available, that he shouldn't have to produce them. And then, that his personal viewpoints on Stephen Avery's guilt and the trial evidence is irrelevant. And, you know, I think for the most part, Netflix agrees with that. We don't need Mr. Griesbach to give us copies of court documents that we already have or could easily obtain from the court. And we also don't really care what Mr. Griesbach thinks of the jury's verdict. We agree that his thoughts and impressions of the evidence at Stephen Avery's trial and whether he agrees that the evidence pointed to Stephen Avery's guilt is really not particularly material. But baked into his opposition is this assumption that the only question in this lawsuit is whether Making a Murderer accurately documented the underlying events. And that then leads to his incorrect assumption that the only relevant documents are the transcripts and exhibits that we could get from the public court file. And as we've, I think, best stated in our reply brief, you know, most succinctly, is that regardless of Making a Murderer's truth or falsity, the plaintiff here, Mr. Colborn, has to prove several other elements, right? He has to prove it was defamatory, and that means he has to show how the series impacted viewers. He has to prove the extent of the damage it caused his reputation, if any. He has, as I mentioned at the outset, an intentional infliction of emotional distress claim, which means he has to show he suffered emotional distress and that Making a Murderer and not some other factor caused it. And notably, and this is referenced in my affidavit at docket 217-1, Ms. Barker has conceded that documents on these topics are relevant and discoverable, and it's obvious to us from documents we've already seen and witnesses we've deposed that Mr. Griesbach has a lot of documents on these topics. So I don't want to belabor the point, but just to give you a sense, documents Mr. Griesbach has reflecting conversations he had with people who viewed Making a Murderer about what they took away from the series and how it impacted their opinions of Mr. Colborn, those are relevant to the damages analysis. And we know that Mr. Griesbach has those because we filed with the court an email, docket 207-7, where he emailed the filmmakers after the release of the series and offered to share with them, quote, local reactions, end quote. We know that he has documents on issues related to Mr. Colborn's alleged emotional distress because there are passages in Indefensible that suggest he had inside knowledge on this, most likely based on private conversations with Mr. Colborn or Mr. Lank or others involved in the trial. And as I mentioned, we deposed Brenda Schuler, who's making this counter documentary on Friday. She also fact-checked Mr. Griesbach's book, Indefensible, the one about Making a Murderer, and testified that she personally interviewed Mr. Colborn in an effort to understand his reactions to and his rebuttal points to the series. She conducted that interview not only with Mr. Griesbach's knowledge, but at his request. And she testified that what she learned was incorporated into the book. And then, you know, we have reason to believe that Mr. Griesbach has many documents relevant to alleged harm to Mr. Colborn's reputation, and specifically whether that harm was lasting or whether it was mitigated, for example, by Mr. Griesbach's book itself or by public statements that Mr. Griesbach made about his book. So there is a sense from the documents that Indefensible was almost a mouthpiece for Mr. Colborn. And if Mr. Griesbach was speaking in Mr. Colborn's defense and promoting his book, that's relevant to damages. On the flip side, there's reason to believe that books like Indefensible and counter speech, like the forthcoming documentary by Ms. Schuler, have actually aggravated Mr. Colborn's damages. So we've seen documents that show on several occasions Mr. Colborn really wanted to speak out publicly in his defense. After the release of Making a Murderer, he was invited to several radio shows. Several journalists wanted to interview him. And he was actively discouraged and ultimately agreed to stay quiet due to his relationships with people like Mr. Griesbach, people like Ken Kratz, who also wrote a book, and his relationship with Transition Studios. And then we've seen documents where where people who claim to be friends of Mr. Colborn actively sought to keep making a murderer relevant, and that word is in quotes here in my office, air quotes, so that there was a market for follow-on works. And of course, Indefensible is a follow-on work. And so if third parties' books and films have exacerbated Mr. Colborn's damages, and if he went right along with that, that is relevant. And again, we have documents giving us a very strong belief, and Mr. Griesbach has never really denied, as you say, he's just flatly refused to respond, that he has evidence related to all of those topics. So, the subpoena is broad. Subpoenas always start broad, and then typically you meet and confer in good faith to narrow them down. But let me say at the outset, we're not asking Mr. Griesbach to produce the same box of documents we can go and get from Calumet County or Manitowoc County. But we are asking him to produce everything else that's responsive to the subpoena.
Thank you. Mr. Meyer.
Sure. Thank you, Your Honor. Let me just take a step back first. There are literally, well, first of all, I happen to live in Manitowoc, Wisconsin, and I happen to have had some involvement in the civil case involving Mr. Avery. Me as well as literally dozens of others. Me as well as all kinds of other onlookers, people like Ms. Schuler, and frankly, dozens and dozens of people that took a very particular interest in it because, frankly, it was a wild story. It captured the attention of the public, and it was everywhere. And in a small community like that, it means a lot. Second of all, Mr. Griesbach was an assistant DA who, of course, recognizing the situation, immediately recused himself, and he did not prosecute the case. To say he had involvement in it, he signed some documents that allowed the transfer, but that's it. He couldn't be involved. And that really kind of sets the stage for what's going on here. Counsel keeps referring to and everything else. We don't want what he got in the public domain. We want the everything else. And that draws us directly to a couple of things that are really, really interesting and perhaps probably more telling than anything else that has been said. And that is, there's about, I don't know, perhaps a dozen other books written by people other than Mr. Griesbach. There are literally dozens and dozens and hundreds of exposés and comments and interviews and just ridiculous amounts of media and other material that is circulating about this with what other people think and their impressions and, whether they thought Mr. Colborn did something he shouldn't do or otherwise or, relevant to damages. But Netflix didn't, this is really where it gets interesting, Your Honor. They didn't choose to go after any of that. What did they do? They went after the one guy that they knew was an attorney and that they knew had a reporter privilege. And I'll get to the reporter privilege, but I wanted to set the stage first. The fact is, there are so many people that are far more intimately involved that actually, ended up creating or personally involved in the facts that set the stage here. That doesn't include Mr. Griesbach. So what I'm telling this court is, and I don't think it's a suggestion, it's an absolute fact. They chose the one person who was an attorney for Mr. Colborn because they knew what that meant. This is not what ordinarily happens in cases. We don't go after the attorney, even though the attorney may have all kinds of facts and information relevant to the case. And that, of course,
let me jump in there. Ordinarily, sure. Attorneys aren't fact witnesses and aren't involved in the underlying events. And regardless of what level of involvement Mr. Griesbach has, I don't think anybody disputes that, I think I'm right. He actually appears in one of the documentary episodes. And that's well before this case was filed. That in and of itself puts this case, I don't think I've ever been, it's very rare that you have a piece of litigation where the lawyer representing one of the parties, had a direct sort of, was an eyewitness to some of the underlying events. And so that makes this case different. I'm also not terribly, I don't find it terribly relevant that there are other witnesses that Netflix could seek discovery from. I'm sure there are, and the fact that they're choosing Mr. Griesbach to seek discovery from Mr. Griesbach as opposed to others, that's up to them. Again, I don't think the fact that he is co-counsel for the plaintiff, it certainly doesn't immunize him from discovery. And so most of what you're saying so far doesn't seem to take issue with the fact that he has potentially discoverable information. And if he does, I'm not sure what basis I would have to deny the motion to compel.
Well, first of all, Your Honor, the Wisconsin's reporter privilege is an absolute privilege. The 885.14 privilege is absolute and taken very seriously. All Netflix showed us with regard to a response was a case from the state of Illinois that doesn't interpret or apply Wisconsin's reporter privilege. It has nothing to do with Wisconsin's reporter privilege. And the fact is, in that particular case, what the court was dealing with was a gentleman that was much like Netflix. He actually produced the material that was in question, that was at the center of the controversy, and that was, potentially of a damaging impact. That's not the case here. That was akin to Netflix's position. So their reporter privilege is not taken lightly. It has not been waived. It was asserted during my conference with Ms. Walker, and we haven't wavered on that at all. And that privilege is an absolute privilege, and that privilege states very explicitly that anybody involved in creating material for consumption by the public that gets published is protected. And it doesn't say, it doesn't care about relevance. It says the circuit court may issue a subpoena to compel a news person to testify or disclose information, etc., if it finds, after notice and opportunity to be heard, that the person requesting the subpoena established, based on information obtained from a person other than the news person, by clear and convincing evidence in a civil action or proceeding, that the complaint states a claim upon which relief can be granted. And the court must find all of the factors outlined in 8.14c, that subsection. It then includes, the court must determine that the news, information, or identity of the source is highly relevant to the investigation, prosecution, action, or proceeding, that the news, information, or identity of the source is necessary to the maintenance of a party's claim, defense, or to the proof of an issue material to the investigation. The news, information, or identity of the source is not obtainable from any alternative source for the investigation, prosecution, action, or proceeding, and that there is an overriding public interest in the disclosure of this news, information, or identity of the source. We have to find the court has to find all of these four things, and there has to be clear and convincing evidence provided by the requestor. That hasn't even been addressed by Netflix. They haven't even attempted to provide clear or convincing evidence because they don't have it. And they know that, because Mr. Griesbach is like so many other onlookers. He did not partake in the arrest of Mr. Avery or prosecution of Mr. Avery or any of these things. He wrote a couple of books, and that's what the reporter privilege is aimed at protecting. We don't want people that express opinions and look at information, and maybe it's evidence in a lawsuit, maybe it's evidence in some other context, to be subjected to this sort of thing. And that's why Wisconsin says it's got to be clear and convincing evidence, and you have to meet these 4 other criteria, none of which have been met. And the fact is, there's nothing unique to what he said or did other than his conclusions or thoughts. And this court, and frankly no court, is ever going to be asking an attorney what they think about the evidence in terms of providing that to a jury as proof of something that's more or less likely. That isn't going to happen. So, and the other thing is, Your Honor, not only is it very, very curious about who they are going after, and that the privilege is an absolute privilege that has to apply, and the strong, obviously the very strong interpretation of that privilege is Wisconsin means it. It's there for a reason, and we do it to protect the press and the members of the press. So we do what? So we encourage discourse, and we encourage people to be perhaps candid and perhaps more expressive and things like that. Heaven help us if we don't have that privilege, and that's a big deal in Wisconsin, and that's why the statute is written the way the statute is written. And I haven't heard any clear and convincing evidence. I haven't heard anything about anything that would be unique to Mr. Griesbach other than his own thoughts and interpretations based on what he heard and saw. And that's not, frankly, that's not even evidence. It couldn't be evidence. If it were evidence, then Ms. Walker would be putting Mr. Griesbach in the position where he has the ability to take the stand and express that evidence. And this court isn't going to allow that. No court would allow that. It isn't what he said or did that creates issues of fact that this jury is going to have to consider. It's what Netflix said and did that create issues of fact. Mr. Griesbach isn't a party or a litigant. He is an attorney representing a party. And he also happens to have had a role as a reporter, something he took on voluntarily, obviously, because of his interest, but not because he had any unique access. Like myself and like so many other people in this community, including the judge, the juries, the witnesses, the attorneys involved in that underlying case, he had access to all this public information and what people thought of it. And the thought that by asking somebody, well, what did you think of it, that creates evidence is pretty hard to understand. But that's really what we're hearing. There's this, what they're really trying to do is create this smoke or haze that, boy, there must be some fire underlying there. Well, there isn't. The guy didn't get involved in the criminal case. He couldn't. He did everything he could to distance himself from it because he had to. But anyway, that's not directly correlated to the reporter privilege. The reporter privilege stands on its own, and it, frankly, that case from Illinois that counsel cites only reinforces the sacrosanct nature of that reporter privilege. It's an interpretation and application of Illinois statute, which is different from Wisconsin, but what it really stands for is that producer of that movie, which is akin to Netflix and the other defendants, yeah, they have information that would be relevant and obviously should be disclosed. But that's not Mr. Griesbach, and frankly, Wisconsin's law is not Illinois' law. So I think with that statement, Your Honor, I'm not sure I have much more to offer, but I sure hope that the reporter privilege is intact. I understand Ms. Schiller is also doing likewise, but I cannot speak for her. I don't represent her, and I don't know what communications or she had with Ms. Walker. I'm not privy to that, nor would I expect to be. But the reporter privilege that's a big deal. And thankfully it's there, or we would have people in the press becoming targets. And that's exactly what Netflix is trying to do here. It's trying to deflect away from its own behavior, which is at issue here, and involve, I think they thought it was pretty neat that they could get the attorney to have to be subpoenaed as a witness or documents subpoenaed without regard to that reporter privilege and not taking it into account. And first they were trying to tell us it was waived. Now they're not even addressing it, or they address it by giving us this case from the state of Illinois that not the same law and is quite distinguishable and frankly supports Mr. Griesbach's position. Thank you.
So I'm looking at the initial written objection there was an initial written objection to the subpoena. Looks like
yes.
It's dated.
Yeah, and then we spoke.
Before?
I'm sorry, and then we spoke, Your Honor. That's all I said. My apologies.
Yeah, so February 24th, but the reporter privilege is not raised in that document. You raised it subsequently in a meet and confer call. Is that correct?
Yes, that's correct, Your Honor.
All right. Counsel for Netflix want to reply to any of that.
Just briefly, one of my points was going to be what you just raised, which is, Mr. Griesbach was required to put forth his objections in writing, and he did not include the reporter's privilege. And as we've set forth in our reply brief, he waived that privilege. Secondly, the Simon case out of Illinois is directly on point. Like, it's kind of unbelievable we found a case in any way, that could speak to this situation because it's so unusual. But we did, and it's like literally the same fact pattern. And it's clear that whatever privilege Mr. Griesbach might have had when he began writing his book, and I want to say at the outset, I represent the media. I assert reporters' privileges on behalf of journalists day in and day out. I take it extremely seriously, and we thought long and hard before we served this subpoena on Mr. Griesbach because, at the high level, I agree with what Mr. Mayor is saying, that our journalists should not be hauled into court to do the legwork of the litigant. But the fact of the matter is, and the Simon case speaks directly to this in a fact pattern we couldn't have created if we had wanted to, that the moment Mr. Griesbach became an advocate for Mr. Colborn and became his attorney and began using the knowledge he gained in writing those books to represent a plaintiff in a defamation lawsuit, he waived the privilege. And I know he's fixated on why him and not all these other people who wrote books, and he's answered his own question. Those other people still have a privilege. And if we had subpoenaed Ken Kratz or anyone else who wrote a book after their legal work on this case was done, they would have asserted the privilege, and we wouldn't have been able to say they waived it because they didn't take on representation of Mr. Colborn. So, that case resolves this issue. And then finally, Mr. Mayor brought up Brenda Schuler and said she's also asserting the privilege as a producer of this counter documentary. And it is true that in her written objections, she mentioned the privilege, unlike Mr. Griesbach. But we deposed her for about 7 hours on Friday. It was a wide-ranging deposition. She answered every question. Many of the questions went to her work and her work product on that documentary, and she answered every single one. So I don't have anything further.
So obviously the Simon case involved Illinois law, and I'm not terribly familiar with Illinois' reporter privilege statute. I'm looking at 88514. So let me just, as I understand the Simon case, I think it was the Northern District of Illinois held that when filmmaker slash witness, subpoena respondent, discovery respondent, when that person became counsel for one of the parties, that acted as essentially a waiver of the reporter privilege, because in essence, by joining one of the litigation teams, the person, shared all of the information that would have been subject to the reporter's privilege with one party, and having done that, basically waived that privilege, and it really wouldn't be fair to say I'm going to waive it only as to one party, not as to both. Is that a fair summary of the Simon Court's analysis, or do I have that wrong? Let me start with Netflix counsel.
Sure. Thank you, Your Honor.
Netflix counsel?
Yeah, Netflix counsel.
Oh, I'm sorry. My apologies.
Yeah. You've summarized it accurately. I think another key passage is at the bottom of page 14 of our reply brief, where the court sort of talks about the different ways things can be shared. Like, you can literally join a legal team and tell everyone on the legal team what you learned as a journalist. The court posits that you can join the legal team and not verbalize it, but just sort of have a mind meld, right? Or you can just become just transforming from a reporter into the attorney and bringing all of the information with you in order to advocate for your client, even if you don't actually verbalize what you know to Ms. Barker or Ms. Burnett or anyone else on the legal team. That is a waiver. And so I'd just point you to page 14 and 15 of our reply brief, which I think crystallizes the holding of that case.
So one follow-up question on in WSStat 885.14, subsection 4, distribution, it says a disclosure to another person or dissemination to the public of news, information, or the identity of a source, as described above, by a news person does not constitute a waiver of the protection from compelled disclosure under subsections 2 and 3.
Yeah, I mean, that's a pretty standard. Oh, I didn't mean to interrupt you, Judge.
How does that, I mean, I could see how one would argue that section, that subsection covers Mr. Griesbach here and prevents a waiver from him having, if he's disclosed all the information that he has to another person, to Mr. Colborn, doesn't this provision say that does not constitute a waiver?
It doesn't, and I can see why someone who doesn't deal with these kinds of statutes might read it that way. This is a pretty common sort of provision in a privilege statute. And what this means is that a reporter can do an investigation and talk to confidential sources, and then he can actually publish a story about his investigation. And the story, of course, is public and, can be used in a court of law. But that just by virtue of publishing a story that is the culmination of his investigation isn't a waiver of the unpublished information that was part of the investigation but didn't get included in the story. And so that's what this sub 4 is designed to guard against. It's designed to guard against a litigant who says, well, you did the investigation and then you published part of it in the newspaper, and so you've waived everything related to your investigation. Obviously, if that were true, the reporter's privilege would serve no purpose because reporters don't just investigate, they publish. But that sub 4 does not apply here.
So that what you said makes total sense to me. Do you have any case law that supports that reading?
So I don't believe there's been any published case law on the Wisconsin reporter's privilege. It's fairly new, but I'm happy to, look at comparable statutes around the country and find case law and provide it if you'd like.
Yeah, I think that would be helpful. Let me say this. My current feeling on all of this, my current thinking, I should say, on all of this, is that sort of consistent with what I've already said. The fact that Mr. Griesbach was, observing the underlying facts well before this case was filed, and not just observing it like any other person living in Manitowoc County. He was much more active, much more in the not just in the background, but was present and is a witness on some level. How material a witness, I don't know. But that makes this an awkward situation, and the fact that he's now representing the plaintiff in this case, it's a unique situation. I don't think the fact that he's the lawyer for co-counsel for the plaintiff shields him from discovery. I think the law is pretty clear on that. I think the fact that that he may have documents that go to proving defamation or to proving or disproving plaintiff's damages, not as a result of him being the lawyer, but as a result of his role before this case was even conceived. I think those things are probably discoverable. The only thing that, and so all of that makes me inclined to enforce the subpoena. The only thing that's giving me pause is the reporter privilege. And so
can I just I'm sorry.
So that's the part that I'm more concerned about, because I think that's the only thing that to me would alter the analysis, would make Michael Griesbach any different from any other third party out there with potential evidence about going to defamation, going to damages, going to intentional infliction of emotional distress. For example, if the respondent to this subpoena has handwritten notes of interviews with the plaintiff, at the time this documentary came out, that reflect what his emotional distress was, or what his thoughts were, or interviews with third parties that would go to whether this was defamatory or not, or harm to Mr. Colborn's reputation. I could see that as in writing this book, he might have notes of all of those things, and to me, those would all be subject to discovery, subject to unless they're protected by the reporter privilege. And then to me, the question becomes, does the reporter privilege apply, and has it been waived by the fact that he then chose to get involved in the plaintiff's trial team? And so that's the one thing I'm kind of hung up on here, I don't have a firm resolution of that issue right now. So that's sort of my current thinking. What I'm going to propose, because I want some more time to look through this reporter privilege issue, and it seems to me, to the extent the parties, so what I'm thinking is that I might ask the parties to give the parties the opportunity to provide supplemental briefing on just that issue, and then maybe reconvene, do that over the next week or so, and then reconvene in a couple weeks. We could at that point, potentially take up where things stand with respect to whether we have that other issue hanging out with these other documentary filmmakers, and whether these documents should be maintained confidential. We could finally resolve that issue at that point too. So,
Your Honor.
Your Honor, may I respond very briefly to what? Go ahead. I'm sorry.
So my inclination is to give the parties, a week or so, 10 days to submit some supplemental briefs on this issue, and then set a continued hearing where we would, sort of walk through those a little bit and hopefully give you a final ruling, and then we could also resolve this other confidentiality issue. So my initial inclination is. I will now give both sides an opportunity to respond to that, and if you have a different proposal, I'm happy to listen. Let me start with Netflix's counsel because it's their motion.
Sure. Thank you, Your Honor. We're happy to provide that additional briefing. I just wanted to raise 2 points. One is I understand why you want that briefing. I don't think you need to reach the issue of whether the holding in the Simon case applies here because, as we point out at page 13 of our reply, Mr. Griesbach never raised the privilege in his written objections, and Seventh Circuit case law is very clear that it's waived for that reason alone. So I don't know that you really need supplemental briefing, but we're happy to provide it to you. And then just in terms of timing, we're closing in on the date where we need to depose Mr. Colborn in late July. I would just expedite the process of reconvening as much as possible because it sounds like you'll only be issuing an order on the motion to compel at that point. And I don't know how long it will take Mr. Griesbach to produce any documents you order him to produce, and we obviously will need them in time for Mr. Colborn's deposition.
Thank you. Mr. Meyer.
Thank you, Your Honor. A couple of things very briefly. First of all, that I never had a chance to respond to Ms. Walker's argument about the application of the Illinois case, but the Illinois case would have application if it was Mr. Griesbach's. If Mr. Griesbach was the defendant because of a allegedly defamatory statement in his books, because that's what happened in that case. The attorney that made provided the information that was at the heart of it and being challenged was the producer and source of this stuff. That's not the case here. Netflix is the producer and source of the allegedly defamatory material, not Mr. Griesbach. And so that case couldn't even apply just by virtue of that. It's why counsel provided it is beyond me because, quite frankly, it supports Mr. Griesbach's position. But the other thing is this, Your Honor. This statute isn't obviously to be taken lightly, nor am I implying that the court is taking it lightly. On the contrary, the court is obviously expressing serious regard, and it's appreciated. But I think what counsel is trying to do is claim there's some sort of waiver here, which I don't understand because we wouldn't be talking about it if there was a waiver, and I'm not sure. I don't think by being an attorney you waive anything, and I think that really is the gist of what that subsection 4 is telling us is, you telling others about this, it doesn't act as a waiver, and it doesn't say by acting as counsel of record you've waived it. It doesn't say those things. In fact, it seems to be telling us just the opposite. You don't waive it. And frankly, that's kind of reinforced by the subsection 5 that makes it absolutely crystal clear that this stuff is not admissible in any judicial, legislative, or administrative action. It just can't be admissible. And that's for obvious reasons. So it's a really high bar, and that is why you have to, it's up to the person issuing the subpoena to satisfy those 4 criteria by clear and convincing evidence. That's not Mr. Griesbach's obligation. Once the privilege applies, because he is a reporter, and there's no question, they're not telling us he wasn't a reporter. He clearly was a reporter. He disseminated published information. he gets the benefit of this statute. It has nothing to do with his role as counsel or becoming counsel, or frankly, whether he was counsel or not counsel. That is just not a factor that 885.14 takes into account. And if it did, obviously it would be providing protection, because it seems to be very, very liberally construed and applied for obvious reasons. But anyway, the point is that this is Ms. Walker's burden and Netflix's burden to satisfy these 4 criteria by clear and convincing evidence. And I think the presumption is obviously that nothing is going to be compelled or produced from a person that is entitled to this privilege, who is a reporter. And what I'm hearing from Netflix is kind of a soft version of this, or interpretation of the statute, but the statute itself doesn't read that way, nor is it interpreted that way, or nor does it apply that way. And statements like, well, I deal with this all the time, so I know the law, well, that's a little disingenuous, Judge, because if you know this law and you deal with it all the time, you know how sacrosanct it is. And it is anything but light, or, it's not a nuisance as Netflix seems to be suggesting. It's a big deal. And I think the court is telling us, I want to be sure I'm applying this right, and I appreciate that opportunity. Thank you.
All right, so let me do this. If I give the parties, I'm going to ask for simultaneous briefs on the application of the reporter privilege and any potential waiver of that privilege. If I give you until next Friday, June 3rd, it seems like you guys are both already on top of this issue. That's expedited, but I hope that you'd be able to get me something. And I'm really certain, and I really want it to be limited to this reporter privilege and its application here. Is that enough time? Can you guys get me simultaneous briefs by next Friday, June 3rd?
Yes.
Your Honor, I'm supposed to be out of town. Would it be possible to? I apologize. I didn't anticipate this, and it's obviously a holiday weekend, and et cetera, et cetera. If we could go a few days after that, would that be acceptable to the court?
How about Monday the 6th?
Great. I appreciate it, Your Honor, very much.
I'm ruining your weekend following Memorial Day.
Right. That one doesn't count, Judge.
So why don't we do that? And then let's reconvene on, how about 2 weeks from today, on June 8th at how about 10 a.m.? Actually, no, let's do the afternoon. How about 1 o'clock Central?
Your Honor, on June 8th, I will be in trial in Green Bay. I'm in trial beginning that Monday, and it looks like, well, knowing the case, it's going to go through Friday. It may spill into the following week, but I'm hoping not.
How about June 14th?
That works for me.
Meyer has, I'm just looking at my calendar here. It looks like I have would the afternoon be acceptable, Your Honor? Because that I could do.
Sure.
Thank you. I apologize for being the
1 o'clock Central Time on June 14th.
Okay, thank you.
Your Honor, I have a note on my calendar. I'm supposed to give a presentation for the SBA that day. I don't have the time in front of me. I apologize. Could we tentatively agree to one? And if there's a conflict, I can let your chambers know.
Yeah, that's fine. And if
okay.
We can, our hearing today took an hour and a half. I don't expect the 14th to last that long. So we might move it to later in the afternoon if we need to. But let's plan on 1 o'clock Central, and just let us know as soon as you can.
Yeah, I'll check as soon as we hang up. I just don't have the date on my or the time on my calendar.
All right.
And so the brief is due the 6th. I want to make sure I'm right there.
Yeah, well, actually, as long as we're not having the hearing until the 14th, why don't I give you 2 weeks to do that? So I'll give you till the 8th.
So Wednesday, June 8th. Okay, thank you, Judge.
All right. Let me also, I would hope I don't even need to say this, but I made a smart aleck comment earlier today or earlier this morning about meeting and conferring. The parties are free to continue to talk to one another, and if you can work this out and arrive at a compromise resolution, you could save yourself the hassle of writing these briefs, and you could save the hassle of having to appear for another hearing. But that's up to you. But let me just throw that out there. So please, continue to talk. And obviously, if you can't resolve it, and maybe that you can't, we'll talk again on the 14th. But anyway, we will put a minute order in resolving the motions as we've discussed. Other than the motion to compel, we will put the briefing dates and the hearing date in the minute order as well. With all that being said, anything further we need to do this morning?
Your Honor, this is April Barker from the plaintiff's perspective. I just want to note for the record, although the fight was obviously between Netflix and Mr. Griesbach's counsel with respect to the motion to compel, if I heard Ms. Walker right, she seemed to be indicating that I allegedly represented or stated and acknowledged that Mr. Griesbach has evidence that is admissible, not only allegedly relevant, but admissible at trial in these proceedings. And I did not make such a statement. I was looking through trying to find where Netflix in its various submissions supposedly characterized what I may have said. I will represent to the court that I, during a conversation with Ms. Walker, initially during which I expressed concern regarding the scope of the subpoena and indicated that, I didn't want to be looking through every document in Mr. Griesbach's house in this case. And obviously we didn't bring our own motion or anything with respect to that at this point. But I believe I said that with respect to Mr. Griesbach's prior work as an assistant district attorney, that he may be in possession of some discoverable information, but I was questioning the rest of whatever they might be seeking. So I strongly object to any mischaracterization of what I may have said during that conversation.
Understood, and I'm not ruling on any of that today. So
yes, thank you, Your Honor.
I'm sorry to prolong this.
No, you don't need to respond.
No, I'm not responding to that. I found the time of my panel on the 14th, and it is a conflict at 1 o'clock. Could we move our hearing to 3:30? I would be free by then.
That's fine with me. We will talk again at 3:30 Central Time on June 14th.
Thank you.
All right, thank you, Your Honor.
Thank you, Your Honor.
All right. And thank you all. Let me also say I appreciate that this discovery issue has gummed up potential depositions and things. I also encourage you to talk about that and when we convene on the 14th, depending on what happens, if discovery deadlines, any of the deadlines need to be adjusted as a result of this dispute and the time it's taking to resolve it, obviously the court is open to that. But I will look to the parties to hopefully agree on how the schedule should be adjusted. And maybe it doesn't need to be. I'm not saying that's necessarily the case, but if it does need to be adjusted, the court would be open to that. But I'll look to the parties to give me some guidance on what they propose. Does that make sense?
Thank you. Yes.
All right. I will keep an eye out for your briefs or for a report that you've resolved this. I say that a little bit tongue-in-cheek, but we will talk to you again in a couple weeks.
Thanks for your time,
Have a good weekend.